Can you hear me now?
Yes.
Thank you, Jesus. You can put it on the group chat that we are live now. Are you sure they can hear me? Are you sure you can hear me? Okay, so this is a continuation of the part 1 of this video. So this is the part B. If you watch the part A, which I would advise you to please do before you watch this video, we are still talking about the part 1 of implied statutes, implied terms by court. So if you watch the part 1 of the video, you would see that towards the end, my mic got off. I tried to, put the situation in order, but it just seemed as if, I think it was a YouTube stuff or something, because it wasn't, getting in order. I thought my mic was bad or something, and then I checked in and it was still working. So I don't know what happened towards the end of that video, but again, we move once again, we get to our class. Now, while we continue our class for today, in last class I was talking about the fact that, we're talking about terms by statute, right? Very good. Sorry, terms by court, implied by court, as opposed to statutes. So when we are talking about terms implied by court, I gave you what the officials bystander statement by who? I gave you the officials bystander statement by Makino in Shell versus Southern Factories, Foundries, I think. And then I told you about the officials bystander rule. And William said in what? In language and the law. He gave us what? 3 tests. And I told you that the first 2 tests belongs to what? The officials bystander rule, right? The officials bystander rule was also backed up by who? By the Mocox case, by Makino LJ, where he told us, yes, you can presume the intention of the parties. Do you understand? And I also told you that when you're talking about the first one is actual intention, the second one is hypothetical or conditional intention, such that when you bring up the example that the term rather, the both of them might not have averted their mind to that term, but when you bring up the term to their knowledge, they will say, oh yes. Do you understand? In this case, they had it in mind, but they did not just express it. That was the first one. So we have the first one and the second one, and the first and the second one comes under what? It comes under the officials bystander test. Then I told you that we had the third one as given by Glanville Williams, and this third one is what? Is fairness and policy, and in consequence of the rule of law, is the one that talks about reasoning and all that. And I told you that when we are talking about this third test, who do we look at? We look at Lord Denning. What did Lord Denning say? Now, from this test, that is, it is clear that the officials bystander doctrine of Makino LJ was also derived from Makino LJ in the doctrine. Was LJ's doctrine rather in the Mocox case. That's by the way. Now the leading exponent of the second view, that this is the first view of officials bystander. The second view is the one of reason. So the leading exponent on the second view, that is that the court can imply based on reason and logic. That the question that I posed to you is, when we're talking about the implied terms of the court do not imply based on reason and logic. The court implies what? On the presumed intention. What could be the presumed intention of the parties if an official bystander stood one place and was listening to the parties? Do you understand? What could be the presumed intention of the parties when an official bystander is standing and listening to the parties? That is what the court is supposed to imply. Presumed intention. Now that presumed could be the actual intention of the parties or the hypothetical or conditional intention. Do you understand what I'm saying? So now, can we leave this official bystander rule? Can we leave this presumed intention or the actual and hypothetical intentions? Can we leave it behind? That's the first view. And then have a second view where the court will imply through reason and justice. The term has not been contemplated by the parties, but the court is bringing that term in as a matter of reason and as a matter of justice or as a matter of fairness. Now, Lord Denning stated in the case of Greaves versus Bayham, Greaves, Greaves, Greaves versus Bayham, Baynham. In Greaves versus Bayham, that's where Lord Denning talked about reason and justice. What did Lord Denning say? He said, in Lord Denning's view, terms are implied by court because they are just. Are you listening to me? Because they are just and because they are reasonable, not because the parties had agreed to them expressly or impliedly, as has been stated in the case of Greaves and Bayham. So, in the case of Greaves versus Bayham, the Lord Denning gave us what? A fourth rule. Another rule rather on the second view. Lord Denning gave us another rule on the second view. What is that other rule? That is the fact that the courts should be able to imply based on what? Reason and justice, right? Now, this was further complicated in the case of what? In the Liverpool case, the House of Lords case of Liverpool City Council versus Ewing. Liverpool City Council versus I want to pronounce it as IRWIN. So that's Erwin or something, or Ewing, whatever it is. Now, I told you that under this second doctrine, this second view, there are two cases that we have cited now. We've cited what Lord Denning said in Greaves versus Bayham, right? Where we are talking about whether or not we can imply terms based on justice and reason. Lord Denning said we can imply. In the first rule, we cited two cases: the Moorcock case and the Sherlock versus Southern Foundries. The both of them used and backed it up with what? With what Glanville Williams said. So Bowen LJ in Moorcock, what's the name of that guy? No, the name of the judge in Southern Foundries. Makino LJ in Sherlock versus Southern Foundries. So we have Makino LJ in Sherlock versus Southern Foundries. We have Bowen LJ in Moorcock. Both of them talk about what? The presumed intention. Makino LJ talked about the officials bystander, which are under the first and second leg of what? Of Glanville Williams' statement rules, right? Right, the third leg is where we now have, which is the second view. The second view is where we have Lord Denning. So when you are citing your cases, two cases for this two view, now we have two cases for this view. So this view is on what? Whether there is reason and logic, whether the court can imply reason and logic into the contract. And Lord Denning said yes. However, in the case of Liverpool City Council versus Erwin, there was a problem. So let us look at the fact of the case. Now, the defendants were tenants in a ninth floor flat of a tower building, which is 15 floor high. So you are talking about, if this is the tower building, 1, 2, 3, 4, 5, 6, 7, do you get 15? And they were tenant of the 9th floor. Let's say this is the 9th floor, right? So which means that there are certain things that you can infer by this. It means that to get to the 9th floor, you need a lift, because if you are what is it called, climbing it, even your legs too will tell you that something is wrong. Do you understand? You need lift, you need stuff like that. So let us look at some of the things that were stated in the case. So the defendants were tenant or in the 9th floor flat of a tower building, 15 floors high, containing 70 flats owned by the plaintiffs, right? Now, the plaintiff is a council. So now the tenant agreement imposed obligation on the tenant, but said nothing about the obligations of the landlord council, right? I want you to follow me. So now, according to the tenant agreement, the tenant have certain obligations. It is there as the obligations under the tenancy agreement, but there is nothing that talks about the obligations of the landlord. Do you understand? Now let's continue with the fact of the case. Now the council, however, retained control of lifts, staircase, and rubbish chutes themselves. Know what rubbish chutes are. So rubbish chute goes from here and then it pops out into a bin, you know, at the end. So it's like a pipe where if you are 15th floor, instead of it to be carrying your this thing down, you just put it, it's a chute, you just put it there, it goes down and then pops out into the bin that is downstairs. Do you understand that? So it's called the rubbish chute. So they were in control of three things. Number one, the lifts. Number two, the staircase. And number three, the what? The rubbish. So yes, as I was saying, The council, however, retained control of the lifts, the staircase, and rubbish chutes themselves. Now, the condition of these common facilities deteriorated seriously. Deterioration means that what? That it became, very bad, partly because of vandalism and lack of cooperation by the tenants. The lift broke down regularly. The staircase were unlit, which means there was no light. The lift kept breaking down, which means they couldn't go through the lift. The staircase, no light. So imagine how that would be even during the day, because it's going to be dark. So it was unlit. And the rubbish chute did not work, which means there were blockages on the rubbish chute already, which should have been cleaned up so that the rubbish can go down. That is the trash. Now, the defendant and other tenants withheld their rent in protest against these conditions. Now, the plaintiff brought an action for possession, and the tenant counterclaimed for breach of an implied term of quiet enjoyment. Both parties succeeded at the court of first instance, and the plaintiff appealed. Now, this is what we are talking about. Now, you know that I said in the agreement, right? I said that the tenant had their obligation, while the landlord had the obligation, right? Didn't have obligations, rather. Their landlord didn't have obligations, but the tenant had obligations. However, the control, you know what obligations are? The things that you must do. However, the control of the what is it called? The staircase, the lift, and the rubbish chute, they were what? They were in charge of the landlord. The fact that they were in charge of the landlord does not mean that taking care of it was in charge of the landlord. Do you understand? When I mean the control, I mean the ownership was in the landlord, not in any tenant. Do you understand? So it's just like if they rent you an apartment, right? You know that the way to get there is not yours. What they rented to you is the apartment. Do you understand what I'm saying? So now that is exactly what. So even the parking lots, if you rent an apartment it has a very big parking lot, is the whole parking lot yours? No, you have a right to park there because you rented the house, but that does not mean you have the ownership of the parking lot. Do you understand? So who controls the ownership? The landlord of the whole place. Do you understand what I'm saying? So in as much as they retained ownership of the lift, the chute, and the staircase, they did not take care of it, whereas they said that the deterioration of those three things were due to vandalism, were due to lack of cooperation amongst the tenants. Vandalism and lack of cooperation amongst the tenants. Now, when the tenant now saw that these things, it's just, you imagine that you want to keep going up 9th floor, go and down, up and down, up and down. You get tired now, right? Especially when there is no lift. The lift is on spot, and even the staircase is unlit, and the rubbish chute is not even working. So they decided to withhold their rent. They did not pay the rent. Now, what did the landlord do? The landlord said, hey, you did not pay rent? Okay, we are going to evict you. And then they brought them to court for retaining the possession of the property, which means that they wanted to evict the people for holding their rent. And then when the people were, oh yeah, come and defend yourself, they said, my lord, we withheld rent because there is a breach of an implied term of quiet possession. Do note that in their agreement, there was no place where they said quiet possession. I'm very sure that you also want to refer back to our title, that is section 12. In section 12, I told you that when somebody buys a goods, that the person has what? A right to, the person who is selling has a condition. The person who is selling has a condition that what? He's the owner of the title, section 12 of the sales of goods. And then there's a warranty as to quiet possession and all that, right? That one, quiet possession and all that is not a condition, right? Is a warranty. Now, in this one, they said there's a breach of an implied term of quiet possession. Now, what they are trying to say, what you need to understand is that this one is sales of goods. Sales of land and rent of land has nothing to do with section 12. Are you listening to me? Sales of land and rent of land has nothing to do with what? With section 12. That one is under sales of goods. This one is renting of land. Another statute governs this one. But at the time when the case was made, there was no statute governing it. But what they are trying to say is, my lord, in as much as we did not agree that there was going to be quiet possession, my lord, it goes without saying that if you give me house, how do I get to the house that you are giving me if the staircase is unlit and I fall a lot of times, and if the lift is not working, and the person who is supposed to make sure that all these things are done is you. Do you understand? I need you to follow me with what I'm saying. There is no law at that time. There might have been a law on sales of goods, but they did not bring this action on that sales of goods. Why? Because the act is for goods, not for land rent and sales of land. There's another statute governing that, but the statute governing that did not have an implied term as to breach of this thing, because if it came under statute, they will not be talking about implied term by court. We will be talking about it under statute in relation to land, right? But in this case, we are talking about implied term by court because at that point there was no statute governing it. So what the defendant is saying is that there must have been an implied term by the parties. It had not been expressly said, but there's an implied term as to what? Quiet possession, okay, quiet enjoyment of my land. So if I am in the house, I should be able to quietly enjoy. If I am in my house, I should be able to quietly enjoy coming into it, no problem. This thing is not working. It's just like saying that you are in a house, right? Your toilet is not flushing. So each time you use the toilet, it doesn't flush. And when it does, the pipe somewhere had burst. Do you understand? Who is supposed to take care of all these things? Your landlord. And landlord, have fun, I take care of them. You say, no be waiting you pay for that. Although what I paid for was what? Was the house, right? However, I am supposed to have what? Quiet enjoyment. I'm supposed to enjoy my house. If the pipe is burst and the person who is supposed to do it is you can see where it's coming from. So the question is, when they took the case to court, the question is, can the court, although it had not been contemplated by the parties, it did not fall under what they had in mind. Do you understand? Neither did it fall under whether or not the question had come out at that point, because your vicious bystander rule will be like, oh, listening to what they were saying to each other, of course they must have thought about the term of who is going to take care of the lift and all that. It was not thought about, so they did not apply the officials bystander rule. What they wanted to apply is the reason rule. Do you understand? So when they got to the court, the majority of the Court of Appeal held, listen to me, majority of the Court of Appeal held that no term could be implied, that they did not contemplate it because the officials bystander rule did not apply. At that point, there was no reason rule yet. Do you understand? So what they were saying, or even if there was a reason rule, the court did not used to follow the reason rule at that point. So now in this case, when they finished at the court of first instance, they applied to the Court of Appeal, appealed rather to the Court of Appeal. When they got to the Court of Appeal, majority, which means that the defendant lost the case. If majority say that there is no term, the defendant lost the case. However, there was a minority statement, which means that Lord Denning said something. Now, Lord Denning said in his judgment that, before we go that, yes, Lord Denning said that in a minority judgment, held, however, that the issue was not whether there was an implied term which was necessary. Now, I want you to also look at something. The majority said that they were not going to imply that term of quiet enjoyment. Number one, because it doesn't flow with the officials bystander rule. And number two, because it was not necessary. The term was not necessary for you to get your house. Are you listening to me? The term was not necessary to have been contemplated by the parties for you to have been able to get the house. Now, this is where we now come up with the necessary rule. Are you listening to me? The necessary. You know, we've talked about the official bystander. That's the first rule, right? Then we talked about what Glanville J was talking about, fairness and in contemplation of the rule of law. That is the second view. Right? Under the second view, I told you that Lord Denning was talking about reason and justice. You can imply reason and justice. Greaves versus Bayham. Right? Now, the same Lord Denning was at the Court of Appeal division. In this case of Liverpool City Council. In this Court of Appeal division, they brought up the necessary rule at the Court of Appeal stage. And majority said that there was no necessary a rule to apply an implied term. But Lord Denning said, although, let me read what he said. He said that the issue was not whether an implied term was necessary, but whether such term was reasonable. So he was not agreeing with his fellow justices. His fellow justices are saying that for a term to be implied under the second view, that it should be something that is necessary for the contract to operate successfully. But Lord Dennis said, no, it is not something that needs to be necessary for the contract to operate successfully. It's something that needs to be reasonable. Anything that is reasonable should be an implied term by the court. That's what Lord Dennis is saying. So Lord Dennis said that held that the issue was not whether an implied term was necessary, but whether such term was reasonable, and this must be decided by the courts. Applying this, he held that it was the obligation of the landlord to keep the lifts and staircases reasonably fit for the use by tenants and their visitors, but by the parties had not committed a breach of this obligation. Now, what Lord Dennis is saying is this: when a term should be implied by the court, if a person is bringing an action and is saying that this action is bringing on implied term by the court, if it does not fall under officials bystander part, that's the first view where it was not contemplated by the parties, then the court can also still imply it based on reasonability. Is that term reasonable to have been implied? But the other members of the Court of Appeal bench did not want to use that test. They used the necessary rule. Is that term necessary to have been implied? Let me talk a little bit about the reasonability rule. It means that when you're looking at the term, right, if you look at it from the necessary point of view, for you to have, this is necessary point of view, where you are going to is B. For you to have B, you must have gone through A, right? So for example, let's look at it from this point of view. Now imagine that there are blocks of flat here. There are 3 blocks of flat. I want you to go with me. And then these 3 plots of flat have this right of way. See, for you to get to these 3 blocks, this block A, block B, block C, and this is the main road. Are you listening to me? Now, everybody will park their car at the car park here. There's a car park here. So when you finish parking your car, you have to come here and walk down to wherever your house is. Now, do you know what the person here is saying? The person here is saying, I am the owner of this house and I'm the owner of this right of way. So I don't want anybody to pass the front of my right of way, like this place. But if he does that, then A will not be able to get into the house. What does that mean? It means that it is necessary that for there to be enjoyment of this, are you listening to me? Enjoyment of your house at A, that you should be able to pass through B. Can you see why it is necessary? Because there is no other place to get through to your house. Therefore, it is necessary. Can you see how necessary works? But when you are saying it is reasonable, are you listening? This is what reasonable means. Reasonable means that now there is a longer way to get there. So instead of just going from your car park and walking down here, you have a longer way to get there. Now it is reasonable for you to follow here than for you to follow this long way. Now what I'm trying to explain to you is the difference between necessary and reasonable. For necessary, there is no other option for you to have taken apart from that. For reasonable, it means that when we are juxtaposing other options, this is the most reasonable one. Are you listening to me? Now, if you have that at the back of your mind, let us then go to what happened at the House of Lords. You know what happened here is what? Is that the Court of Appeal, right? They said that it was necessary. The majority said that it wasn't necessary, right? While Lord Dennis said that although it was not necessary, in fact, the test that we should apply should not be the necessary test, it should be the reasonable test. The House of Lords, especially Lord Wilberforce, said something more interesting. Now, on appeal by the tenants to the House of Lords, Lord Dennis's view that the tenancy agreement contained implied terms creating obligations on the part of the landlord in relation to the common features was upheld. Very good. And then what happened? Was upheld, and but not on the grounds of implied covenant to take reasonable care to keep the common facilities reasonably safe and fit for but not on the ground of an implied covenant to take reasonable care to keep the common facilities reasonably safe and fit for use by the tenants, their families and visitors, but on the grounds of necessity. So at the High Court, you know that the other judges at the Court of Appeal, they said what? They said, oh, the test we are applying is the test of necessity, right? But in this case, it does not apply because it is not a necessary thing that those places, that's the lift, the stairs, and the rubbish chute, that they must have been done for you to have quiet possession, right? That is for us to imply quiet possession and the fact that it has been broken. So those places need not be taken care of. So it's not a necessary thing that the landlord must have done it. That's what they said. What Lord Dennis said is that whether or not it's necessary is not what we are looking at. It should be whether or not it is reasonable, and in this case it is reasonable that it should have been done. But then when they appealed, the House of Lords held that yes, there is a breach of an implied term, but not on the grounds of reasonability, but on the grounds of necessity. So it was inverted. The courts of appeal said no grounds of necessity. Lord Dennis said there's grounds on reasonability. But when they appealed, the House of Lords said there is a ground on necessity, but no ground on reasonability. So let us look at what Lord Wilberforce said at the High Court, at the House of Lords. In his judgment, Lord Wilberforce stated that terms can be implied if they are of custom of the trade, on the ground that without them the contract would not work. That's part of what Moorcock's case said. But terms cannot be implied simply on the grounds that they are reasonable. This is what he's saying. Lord Wilberforce at the House of Lords is directly saying to Lord Denning that he does not agree with him, that you cannot imply terms. Tell me where I stop, please. So yes, I'm sorry that it's taking this much. I have a lot of what is it called? A lot of network issues. I'm sorry about that. So yes, as I was saying, Lord Wilberforce is directly telling Lord Denning that you cannot imply terms into a contract based on whether or not it is reasonable. You can only imply terms based on whether or not it is necessary. And I want you to follow me on what Lord Wilberforce said. Lord Wilberforce held that the following terms must be implied into the tenancy agreement. Now, I want you to look at the reason of Lord Wilberforce. Now, this is a tenancy agreement, right? And according to the tenancy agreement, there's obligations, there's this, there's that. Now, this is the landlord, right? And then this is the tenant. This is the tenancy agreement. Landlord, tenancy agreement, tenant, right? Now, everything has been expressly stated here, what they want. However, this issue on who to take care of what is it called? A staircase, lift, and all that, it has not been stated here. Can we imply it? That's what they call quiet possession. Can we imply it into the contract? Now, according to the first rule, whether or not an officious bystander will look at the both of them when they were talking and say, yes, now they contemplated it. But in this case, the official's bystander test will fail. Why? Because we cannot tell whether or not they contemplated it. So we now look at the second one. The second one is reasonable, according to Lord Denning in the case of Grace versus Bayham, and also the same Lord Denning at the Court of Appeal in this case of Liverpool City Council versus Ewen. Now, the question is, can we imply the test of quiet possession into the contract? Can we imply it into the contract? Lord Denning said yes, it can be reasonably implied into the contract. And the Court of Appeal said no, it cannot be necessarily implied into the contract. So we are looking at reasonable versus necessary. Then Lord Wilberforce in the House of Lords directly told Lord Denning, you cannot reasonably imply terms into a contract. You can only necessarily imply terms. So now Lord Wilberforce now said that yes, this term, that's quiet possession, can be necessarily implied. So now let us look at the logic of Lord Wilberforce into arriving at that conclusion that that term can be necessarily implied. Now, A, that there is a grant of exclusive possession to the tenant. Now, he looked at the fact that the tenant, let us look at this guy here. This guy has what? A grant of what? Exclusive possession, right? Then B, a covenant of quiet possession as a necessary incident of letting. What do you mean by quiet? You know, when you say as a necessary incident, imagine that you are given a house, right? And other people keep barging into the house and they say, they don't pay your landlord, don't pay your landlord. When you are saying quiet possession or quiet enjoyment of your house, it means that you should be in your house and you should have peace, right? You should be in the house that you rented and you should have what? Peace. You should be able to cook in your kitchen. You should be able to use your toilet. You should be able to have water run in your house, because these are things that are necessary for the enjoyment of your house. You should be able to get to your house. Do you understand? You should be able to get to your house, because imagine that now there is this other route. The only way to get here is to pass through here, right? It is obvious that when the party is selling this house to A, if the party is selling the house to A, then there should be an implied term which is necessary in the contract that he should be able to get to his house. If he's not able to get to his house, then there's a breach of an implied term as to enjoyment. Do you understand what I'm saying? So in this case, we are saying this. Can we say that the fact that the stairs are not lit, or the lift is not working, or the chutes are not properly working, can we conclude to the fact that that is what? That is a breach of implied quiet possession? Before we can talk about breach, the first question is, does it exist? And what Lord Wilberforce is saying is that, let us look at the C of what Lord Wilberforce is saying. He's saying the rights of A and B are useless unless access is granted to the staircase. Now, I want you to look at what is A. A is what? Quiet possession of your house. This is Lord Wilberforce's judgment. He wants to show you why he's arriving that quiet possession was necessarily implied. So he's telling us that we have A. A is that there must have been exclusive possession of the apartments, right? B is that the covenant of enjoyment is what? Is implied. The covenant of quiet enjoyment is a necessary incident of letting rather. So this marker is quite faint, but we have A, we have B. What is A? A is what? There is a exclusive possession. A is exclusive possession of the house. That means that you rented your house and you have your house. It's just like you are a student and you went to rent your house in Abule Oja or something in Unilag, and you have your house. The second one is that there is to be quiet enjoyment as necessary incident of letting the house. Quiet enjoyment. That when you were letting your house, when you were collecting the house, one of the reasons why I collected the house is because you wanted privacy. It's because you wanted to do your things in your own house. So quiet enjoyment, don't look at quiet enjoyment as sound alone. Quiet enjoyment goes as far as going to because of the word quiet, it goes as far as going to whether you have water in your house, whether or not there is kitchen. Imagine that you want to use your kitchen, the kitchen that they let you, then somebody from the other house is now coming to you in your kitchen, that when you entered, you inspected, they say, that's going to be your kitchen, and that person is telling you that the landlord told the person that that kitchen is supposed to be shared, and you were like, no, we did not agree to this one. No, when I entered the place, although we did not expressly say it or something like that, but this kitchen is for me, and then the other party is always coming in, frying puff puff, doing this, doing that in your kitchen, and then you're like, no. Do you get? So when you're talking about quiet possession, it doesn't just have to do with the sound. You also have to do with the toilet and other things, and kitchen and this and that. So when I was looking at the what is it called, the pipe that I told you that you are flushing your toilet and pipe is coming out and then it's smelling. imagine, can you enjoy your house when the pipe of the old toilet thing has burst and everywhere is stinking? Can you enjoy the house? So those are things that are part of the necessary enjoyment, like necessary incident to the quiet enjoyment of your house. So the first thing is you must have had exclusive possession. Now, for you to, there's also the fact that quiet enjoyment is a necessary incident of collecting the house. Now, the C is that A and B, this is what Lord Wilberforce said, A and B is useless or are useless unless there's access to the staircase, which is reasonable. Can you get to your house which has quiet possession if there is or enjoy the which has exclusive possession, or enjoy the quiet enjoyment of your house on the 9th floor if you cannot pass through the staircase? When they say the staircase is unlit, which means that you can be falling down and all that, can you get to the 9th floor if you don't pass through the staircase? So it is an implied term as a matter of necessity. What Lord Dennis said is that it is as a matter of reasonability. The judges are saying you cannot imply as a matter of reasonability, you have to imply as a matter of necessity. So as a matter of necessity, you should be able to use the staircase. Are you listening to me? So that's what Lord Wilberforce is saying. Then there is a D. Having regards to the height of the building, the demise is useless without access to the lift. Now, in land law, when you hear the word demise in land law means letting of a property, DEMI, but in English it means when the person is dead. Do you understand? The demise of somebody is dead. But in land law it means when you let the property. That means if I'm letting my property to someone, it's called a demise. So what Lord Wilberforce is saying is that having regards to the height, because of how 9th floor, long, not first, not second, if it was like 3-story building, this thing, then 1, 2, 3, then go 4, then go 5, then go 6, then go 7, then go 8. Do you get? Imagine that you just dropped your car key or something at home, and then and you are rushing. You then have to run back 9 floors and come back down. Then you forgot another file. Run back. Do you understand? So, having regards to the height of the building, what Lord Dennis said is that the demise is useless without access to a lift. That means that you giving him the property is useless without access to a lift. Imagine someone that is staying on the 15th floor and there is no lift. What do you want to kill yourself? Do you understand? So what Lord Wilberforce is saying is that these things that Lord Dennis is saying that they are reasonable, it's not about reasonable. We need to look at it from the angle of whether or not they are necessary. You just imagine that there is no step. You can say that it is necessary to have step. Do you understand? Now we said considering the height. He didn't say that in every building there must be lifts. He said considering the height of the building, the demise, that is the giving of the property, is useless if there is no lifts. Do you understand? So you look at, when you are looking at this necessary test, you look at it based on the fact of each case. Look at whether or not they are alternatives. If there are alternatives, then you will say which one is more reasonable than the other. If there are no alternatives, that is when you say that this one is necessary. Are you listening to me? For example, where there were alternatives here, that's when you can look at the reasonable test. But the reasonable test is not applicable according to Lord Wilberforce in the case of Liverpool, blah, blah, blah. If this guy says that, I'm not going to let you pass, since there are for every reasons in necessary, that's the only thing. The question is, how can you get to a 15th step? There's one day that your leg will break. Do you understand? There has to be lifts. It is necessary. Do you get? It is a necessary requirement. That's what Lord Wilberforce is saying. I think there's an E part. He said the same thing applies to rubbish chutes. Now, this rubbish chute that has been blocked. So, as a necessary thing, it must be there. Why? Because imagine somebody from 15th floor going to drop bag of dustbin, maybe every day, going to drop it down. Can you imagine that? Do you get? So the rubbish chute is also a necessary part of the building. So we are, according to Lord Wilberforce, we are implying a breach of quiet enjoyment because the landlord has not been able to do these three things: stairs, lifts, and rubbish chutes. Not because it is reasonable, but because it is a necessary thing to be done. It is the necessity of the term that is making us imply it into the contract. Because without it being in the contract, they will not be able to enjoy the house. So for them to enjoy the house, it has to be in the contract. So it is necessarily implied into the contract by the court. And that is the second view. Lord Denning is saying no, it should be reasonably implied. Lord Wilberforce said no, it cannot be reasonably implied, it has to be necessarily implied. Do you understand that? And then, in order to determine who was to maintain the services in good condition, the test applicable was that of necessity. Without them, life in the premises would be impossible. The subject matter of the lease, that is the high-rise blocks, and the relationship created by the tenancy demanded of their own nature subcontractual obligation on the part of the landlord. The test was that of necessity, and the standard must not exceed what was necessary in regards to the circumstance. There was no absolute obligation to repair, but an obligation to take responsible care to keep in reasonable repair and usability. The tenants therefore had their own responsibilities. The council had made consistent effort to considerable expense to deal with these problems and had performed its obligation as implied under the contract above. Lord Salmon, in that same case, House of Lords, summarized the position of the House in these words: I find it difficult to think of any term which it could be more necessary to imply than one without which the whole transaction will become futile, inefficacious, and absurd. Can you see that? I find it difficult to think of any term which it could be more necessary to imply. Now, what he's trying to say is that without this term, I think this is the test you should use, where the court will necessarily imply. Without this term, would this contract become what? I want to use this word: futile, inefficacious, and absurd. That when you're in exam hall, just apply the test of Lord Salmon. Now, without the term of the ability to pass this place, would the contract of sale of land to A be futile, inefficacious, and absurd? That's the question. And the answer is without an alternative, yes. Without an alternative, yes. Because it's absurd that you not be able to enter your house because B has blocked the road. So therefore, there is no way to get to the house. But if there is another way, there is another thing to look at whether or not it's absurd. Imagine. Can you hear me? Can you hear me? Okay, so moving on. What was I talking about? Yeah, I was talking about what Lord Salmon said, and I said we should look at the test. Lord Salmon said, I find it difficult to think of any term which it could be more necessary to imply. So imagine to imply that one without which the whole transaction would become inefficient, absurd, and futile. Now imagine anytime you want to apply this necessary test, is it such that, or you are arguing in court or in a Muth session, is it such that without the term being implied, the contract, according to Lord Salmon in Liverpool City Council versus Ewing, is it that the contract would be absurd, inefficacious, and futile? If it's such, and I told you that when you're looking at this property here, imagine that they sold this to this person and then they didn't give the person the right to pass through this place. So if they didn't give the person the right to pass through this place, then the sale of the land to this is what is absurd. It is futile, because then you will not be able to enjoy your quiet possession of getting to the house, right? You won't be able, so it has to be implied that you should be able to get in. If there is an alternative route, and that alternative route is still such that you have to pass miles, if it's, maybe this one is 30 seconds to 1 minute, but this one will take you 2 minutes, it's still within the bounds. But if this one is like 30 minutes to an hour, please, can you hear me? It's disconnecting because your battery is low. Okay, so let's continue what I'm saying. So, like I was saying, I would like you to apply the test given by Lord Salmon, very importantly, when you are, given by Lord Salmon, very importantly, when you are, answering this question in exam. So let's continue with our notes. It says that it would appear question in exam. So let's continue with our notes. It says that it would appear, therefore, that in addition to the test of presumed intention and business efficacy, which has been expressly recognized by Lords in that case, we have now the test of necessity. A closer examination would, however, reveal that in substance, the test is not different from business efficacy test. Moreover, all the earlier cases appear to have been decided on the basis of the combination of the officious bystander test and that of giving the contract business efficacy. Me, I feel that the officious bystander test, and the business efficacy test, are not so the same as much as that of the necessity. Is business efficacy and necessity that makes sense to me, that are the same as the test. Because if you look at it, does it make sense that A will get to his house without the right of way? Does it make sense that you will rent a house when the toilet has burst and then everywhere is stinking and smelling? That's business efficacy now. Do you understand? So it doesn't make sense because you are not enjoying the part of the contract, the part of the business that you've made. So therefore, the court will have to imply that, so the necessity test to me is the same thing as the business efficacy test, as far as I'm concerned, because if you take away the necessity of this implied term, then the business efficacy will not be there anymore now. Do you understand what I'm saying? But they are saying that there are three tests. The presumed intention, which is with the presumed intention test, is the officious bystander test. That's the presumed intention. The business efficacy test to me is the test of necessity. Do you understand? So the presumed intention is the officious bystander. Business efficacy test is the what is it called? Is the necessity test. And then let's go to our Nigerian case. Our Nigerian case, which I'll try to do finish as fast as possible. The plaintiffs were engaged by the defendant to carry out bush clearing along the Warri Ugeli Road at $9 per yard for the purpose of extending electricity supply to Ugeli. The defendant intended, to the plaintiff's knowledge, to install electricity poles and cables along the cleared path. After carrying out this agreement, the plaintiff claimed extra payment for the felling of trees along the route on the ground that bush clearing did not. The court at AKJ held that although the contract did not expressly stipulate that the plaintiffs were able to cut down the tree on the route, there was an implied term to that effect. Now, in order to clear my mind, this is what the judge said. After reading out what the judge said and the whole case, I will explain. Now, the judge said that it's clear to my mind that the plaintiff knew that he was to clear the bush to extend transmission line to Ugeli Township, and that was why he had to clear 10 feet breadthwise along the line. What is the idea behind that? It is to prevent obstruction to the transmission lines. Now, it is a matter of knowledge that transmission lines do pass only several feet above the ground, as at least in this country. So when the plaintiff was asked to clear the bush for the line, it was clear that he was to remove obstructions to the line by felling trees of such height as would obstruct the line. And to refer to Makino in Shello versus Southern Foundries, if while the plaintiff and the defendant were making the contract, an official's bystander were to suggest that they expressly stipulate therein that the plaintiff was to cut down the trees along the line, I am left in no doubt that they would testily suppress him with a common of course. Now, this is what the judge is saying. But before I go to that, Gandhi versus Pfizer, we have the case of Gandhi versus Pfizer, and we also have the case of Ray Comture Commercial and Versus, Powers, Son, and Co. Now, I wish I could say all this, but I'm very sure that my system is quite low and there is no light and it can go off at any point. So, permit me if I'm not able to read out the content of the cases, but I want us to look at the Nigerian case. I want us to look at the Nigerian case of Okotete versus Electricity Corporation of Nigeria. Okotete, and that was the fact of the case which I read on earlier. Okotete is spelled Okotete. Okotete versus Electricity Corporation of Nigeria. Now, what happened in the fact of this case as we round up this class? What happened in the fact of the case? Yeah, we are talking about some group of people were told to come and clear bush. Some group of people were told to come and clear a bush. And then while they made the contract, this is it, bush clearing. Why did they make the contract? They make the contract because they wanted to install poles, electricity poles. They wanted to extend electricity poles to Ugeli in Delta State, right? So, then there was no electricity in that area. But for the poles to be erected, they needed to clear the pathway, and you can tell that it's going to be a lengthy pathway. So they intended to clear the pathway, and they made an agreement that for every yard, I think, of which you are clearing, is going to be $9 per yard. So for bush clearing was the word that they were using. So for bush clearing, it was going to be $9. Do you understand? And then they agreed and they continued contract. All of a sudden, the bush clearers came and said, okay, we have had an agreement, right? But tree felling is not part of bush clearing. That for them to clear the bush, they needed to cut the grass and the weeds. However, you know that they are when there is a forest, you know that there will be tall trees. Please check if that thing is still working. You know that there will be tall trees and all that. So when you are talking about bush clearing, they are now saying that, those tall trees did not come under the contract that they had in mind. That what they were only doing was clearing, or thinking at that point was clearing bush. Now I want you to use the officious bystander test to look at that. What was the essence of the contract? For them to what? Erect poles. When they came and said, oh, I want you to clear the bush, what did they mean? What will you, an officious bystander, what will you think of? Of course, you will think that when they say clear the bush, why? Because I want to have a pole of electricity per everywhere. When I tell you to clear the bush, I'm also telling you to fell the trees. But they are saying, no, that cannot be implied into the contract. That the only thing that we expressly discussed was what? Was, what is it called? Was on a bush clearing. And then the court held, Atake J said, well, if I'm to look at this contract from the point of view of an officious bystander, the question will be, this, that we are using officious bystander test, not necessity. This one, necessity does not apply at all. What we are looking at is the officious bystander test. So, there are two tests, like I told you. The officious bystander test goes to the presumed intention test. So, what will be the presumed intention of the parties? The necessity test goes to the business efficacy test, in such a way that when we apply the dictum of Lord Salmon, where he says that where you remove this particular term, it makes the contrast fertile, inefficient or something, and absurd, so that is the business efficacy or the necessity test. But this one is the officious bystander test. They are not used together, they are used interchangeably in the alternatives. Do you understand? You either use this or you use this. Not that you must use this and this, is or this. Good. So in this case, we are using in the first case, we didn't use the officials bystander. What we used was what? That's London City Council. We used the necessity test. In this case, we are using officials bystander. Now, as an officials bystander, I want you to stand and look at the parties making contracts. So this person is telling this person, I want clear bush. Oh, okay, I want clear bush because I want erect pole. In your mind, what should be the next thing? That means that anything that would be in the way of the pole that you want to erect should be cleared. Do you understand? If he's telling you that he wants to clear the bush, why? Because he wants to erect pole. Then the next thing is anything that is going to obstruct the erection of the pole should be cleared. That's what me as an officious bystander will be looking at. The same way I told you. Now imagine that you want to go to Ashake's party and then they said that the party is all white party, and you say you want to buy and sew clothes, and you hear that the party is all white. As an officious bystander, can you wear red to an all white party? It is called all white for a reason. Do you get? So you are saying that I want to erect pole and I want to clear bush clearing. So you are not saying that, oh no, bush clearing is only for grass and weed, it doesn't apply to pole. The same way the tailor can say, oh no, you said you want to do any cloth that you want, right? So me, I just went to sew any color, but I told you all white. Why are you sewing any color? The same way we say, but I told you I want to bring electricity poles. So why are you telling me that it's only grass and weed? Do you understand? I'm telling you, clear the bush because I want to erect electricity pole. So why are you telling me that? Do you get? So as an officious bystander, that's why he applied the test. If you look at the note that I sent, he applied the test of what? Makino in Shellor versus Southern Factories, where the man said, the judge said that if we have an officious bystander who is asked the question, did they contemplate this, even though not expressly but impliedly, the judge said, Atake J said that if I am the official bystander, of course, it is contemplated that not only the bush and the grasses should have been cut down, the pole as well, the trees should be fell down. Do you understand what I'm saying? So that is how to apply the officials bystander rule. So when you are in the exam hall, this is just the part A, the part 1 of this lecture. We will conclude our lecture in the part 2. But when you are in the exam hall, what are you supposed to do? Like I told you. Is it? Okay, can you hear me? I need to know you can hear me. So yes, another network issues. So sorry about that. So as I was saying, so if you're in the exam hall and you are seeing tests on officials on terms implied by court, if it's an essay question, you can just go straight to the point. This is what they want you to write. If they want you to write everything for them. But if you see a problem question and you see that problem question is not on the presumed intention, is on necessity, what do you hit on? You hit on what Glanville J has said. You hit on what Lord Denning said in Greaves and Bayham. You hit on Liverpool City, Liverpool City Council versus Ewing. Then you look at the Court of Appeal, what did they hold? You look at what Lord Wilberforce held at the High Court. You discuss it in relation to the facts in issue. Do you understand? In my next class, which is going to be the part 2 and final class on term of contract, and also the final class on term implied by court, we are going to be talking about more cases. But at this point, I just want you to have a perspective into what we are talking about and how I expect that you are going to handle this question in the exam hall when you see it. So you know that there are two things, right? Either presumed intention or officials bystander rule, or you have what? You have a doctrine of necessity, or that's the necessity test, or the necessity test, or the business efficacy test, right? So when you're in exam hall, if it's essay question and they tell you discuss all of them. If they tell you discuss just this one, mention this one and discuss this one, all of it. If it's problem question, look at the problem very well. Is the problem on presumed intention? Is it on the officials bystander rule? If it's not, don't raise it. If it's on the what is it called? The other one, which is on necessity, then raise necessity, answer it. If it's on officials bystander, raise officials bystander. Quote the Mocox case, quote Shellor and Southern Foundries, quote Okotete versus Electricity Distribution, I think. Those cases, quote it for them. There are two different cases for two different tests, and quote it for them. I'm going to give you more cases in next class where I'll be discussing on the cases and round up finally on implied terms by court. I will see you in my next class. Thank you very much.